Our next speaker is Austen Zuege. Austen is a shareholder at Kinney & Lang, and he will be speaking on Oracle versus Google and its impact on software development and protection.
Good afternoon, everyone. I just want to remind you that we do have question sheets. If you have any questions that you'd like to leave for any of the presenters, we'll be answering those at the end of the program today. There's also a comment sheet with some open-ended areas. You can fill in any comments you like. Austen was great. Really liked Austen's presentation. The sky's the limit. Today I'm going to be talking about the Oracle versus Google case. And this is an important set of pending litigation currently before the Federal Circuit on appeal, impacting what exactly should be protectable when it comes to software. For those of you familiar with copyright law, this Oracle-Google case, in a sense, pushes against the case from the 1990s, Lotus v. Borland. Now, we'll talk about that a little bit later. But in a way, Oracle is pushing a little bit against the tide when it comes to what has been considered protectable in software to date. So I'm going to start today going over a little bit of background about the case because it's not at all straightforward exactly what is being disputed. We'll talk a little bit about the issues in the pending litigation. And throughout, I'm going to be commenting on the impact on copyrightability of software presented by this case. Now, the significance here as well extends to the realm of licensing. And we often get a lot of questions about open source software and what are current issues surrounding those types of arrangements. And this case does have some implications for when open source licensing will or will not apply. So I'll touch on that a little bit as well. Now, when you talk about IP litigation today, probably the leading topic you'll hear about is patent trolls. And last year, more than half of all patent litigation involved so-called patent trolls. Copyright suits, more or less steady. But there are still some cases that deal with clashes of the titans, if you will, where you have large, well-funded companies battling it out in the courts over IP. In this case, Oracle v. Google is exactly one of those. So the case deals with Java, and that word really describes a number of different things, none of which are really that clearly spelled out in the pleadings if you've looked into this case at all. The product goes back to Sun Microsystems, who developed Java in the 1990s. It was first released in '96, and it includes a so-called platform-independent programming language. So this is a way of writing computer software that's independent of what type of computer or device you're going to run that software on. So Windows, Macintosh, you name it. In theory, any type of computer could run the same program. The saying that Oracle and Sun developed was write once, run anywhere. So a programmer didn't have to rewrite code to suit different computers that might run the same program. They just write it once and any computer can run it. That was supposedly the breakthrough here with Java. Now, there is Java, the programming language, which is what computer programmers use to write their software. And then there's a series of other platforms and packages that go along with that programming language that allow computers to run programs written in the Java language. And that's really where we touch on the issues involved in this Google litigation. There is something called a virtual machine, which I'm going to explain a little bit further in just a moment, that can include what are called packages. And these are bits of software that include common functions, things that would be frequently used by a variety of different computer applications. So these are things that save time for computer programmers. It's something that can be reused again and again. Examples being things like a simple mathematical comparison. You want to determine which of two numbers is larger. That's something that a lot of different computer programs might rely on, and there's embedded functionality in the Java platform. So a computer programmer writing a new application can rely on what's been done before. Other examples might be opening an internet connection or something to that effect. These packages can be divided into sort of two aspects, at least from Oracle's perspective. First, you have the declaring code. This is what identifies these pre-written packages and allows other applications to interact and rely on the pre-written aspects. Then there's the implementing code. This is sort of the meat and potatoes of these packages. It's what actually performs the work. Now, I've mentioned Sun Microsystems here. In 2010, Oracle bought Sun, which included all their Java technology, and purchase price there was in the multi-billion-dollar range. So it's a valuable product here at stake. To give you a little bit better sense here of what I mentioned earlier about virtual machines, what I've got here is just a very simple cartoon picture. You've got a computer or device. In this case, we're really dealing with smartphones, so not necessarily your typical desktop computer, but small mobile devices. But really, any type of computing device could be used here. What you then have on the right are applications. These are the things that computer programmers write. This is the program someone's going to want to run on some computer. And this application is written in the Java language. But to run it, there is a virtual machine, which is something that stands sort of in between the actual application and the computer that's running it. And this is essentially another piece of software, a platform that translates the application into the specific language that the computer understands. So the significance of the way Java is configured is that you can write one application here, and by having a virtual machine over here, you can run it on this computer, or with a different virtual machine over here, run it on an entirely different type of computer over here. The same application works on both. You don't have to rewrite the entire program in a different programming language. That is in essence, what Java tries to accomplish. And I mentioned these packages. Those are things that reside inside the virtual machine and are available for these applications here over on the right, the blue ones, available for programmers to call up and use whenever needed. The programmer might not use all of them, might not use any of them, but they're available. And that is really the core of what's at stake in this Oracle versus Google litigation, is right here, the virtual machine and these packages. Now, Java has a history of litigation. You may have heard about prior litigation. For instance, Sun and Microsoft had a series of lawsuits, and first was in the late 90s, where the allegation was that really Microsoft was trying to sabotage Java by introducing non-functional or less functional equivalents. That ended up settling, but they were back in court again. And you notice the amounts here. We're talking billions of dollars at stake in these products. Now, when we turn to Google was trying to enter the smartphone market. If you're familiar with the company, as I'm sure you are, they are primarily known for internet searching. They have probably the leading internet search engine, and they make most of their money, their core business, off selling advertising. through that platform. But they wanted to enter the smartphone market to get their foot in the door on searches, internet searches that were being performed with these smartphones. So they sought to develop their own operating system for these smartphones, and they talked to Oracle about licensing the Java technology. Those talks began in 2005, but ultimately didn't lead to any sort of agreement. And as a result, we ended up with this lawsuit, which involved both patent infringement and copyright infringement allegations. Now, all this centered around a piece of this Android operating system that Google developed called the Dalvik virtual machine. So if you recall from my slide a moment ago, we're talking about the virtual machine right here. And so the allegation was that that infringed copyright and that there were also patent violations. Now, within this virtual machine, there are these packages which are arranged in a sort of a library. So there are all sorts of different pre-written computer software packages that include all sorts of different subcomponents arranged in a very complex library. What I've got here on the screen is just sort of a generic example of how those are written in the Java language, and how a computer programmer can call up a particular class by filling in the class that they desire and the particular method at issue. What Oracle has accused Google of doing in this Dalvik virtual machine is copying the organization and layout of these classes, methods, things that reside inside their packages. Google wrote their own implementing code, so it wasn't that they copied everything wholesale. What they did copy was certain definitions and the organizational structure of these packages. Oracle's main complaint was that Google did not take what they call a specification license. Oracle had been offering 3 different types of licenses to their technology. The first is the general public license, which is really when we're talking about open source software. That's where, in exchange for access to Oracle's technology, the licensee contributes back or makes their software available publicly. So in exchange for that sort of arrangement, but without any money changing hands, a party can get a license to Oracle's technology. The second, which was what was really at issue with Google, is what's called a specification license. So it's the ability to access this declaring code to gain access to these pre-written packages that Oracle provides, but in that organizational structure, but at the same time writing their own implementing code. The third and most extensive license would be the commercial license, which is sort of having access to everything that Oracle provides. Now, while the specific issue in this case was the specification license, the outcome of the case will really impact also the general public license or open source scenario, because the district court found that this declaring code was not copyrightable. So therefore, Google did not need a specification license because there were no copyrightable elements. The same would go for another party who is considering this general public license. They wouldn't necessarily need it if the software code at issue was not copyrightable. So you would be able to make use of that without having to disclose your work publicly, as would otherwise be required under that general public license. So the district court case was in California. Oracle was originally seeking about $6 billion and an injunction. They had an assortment of patents at suit, but during the course of the case, all but 2 were dismissed. And there were also these copyright infringement claims. Now, some tend to characterize the district court litigation as starting with patent infringement and kind of turning to copyright infringement as the patent claims didn't pan out for Oracle. At least that's how Google would have it. There was an interlocutory appeal here over an alleged privileged email where a Google engineer was indicating that they thought they needed a license, and that was the only way forward. Naturally, that's something Oracle wanted to get in there, and they mention as many times as possible. The outcome in the district court was that basically Google won on all the patent issues. No infringement, but the patents were not ruled invalid, so the patents held up. But on copyright, Oracle did win on really some minor instances of copying. So there were a few things that Google had indeed copied wholesale, but they stipulated to $0 in damages. On the more significant copyright issues, the court said that the material was not copyrightable. So the jury did consider whether there was infringement, and the jury did say that there was infringement, but the judge ruled that that was not copyrightable material, and so there was, of course, no damages on that. Google basically won on the rest of those copyright issues. Now, the rationale here applied in the district court followed a line of cases that apply a test that, in essence, filters out non-copyrightable elements. So the first step in this analysis is to identify things that are so abstract as to be ideas. In the realm of copyright law, ideas are not copyrightable, but particular expressions can be protected. We call this the idea-expression dichotomy. And related to that is something called the merger doctrine, where if there is only essentially one particular way of expressing a particular idea, then we say that the idea and the expression have merged. And when that happens, there won't be copyright protection, because otherwise it would amount to protection on the idea itself. So that's the sort of abstraction test that's applied. The court identifies what's abstract, filters that out, and then you are left with whatever is copyrightable in the end. Here the judge said all you're left with are unprotectable names and short phrases, and the structure and organization is unprotectable as a command structure for a system or method of operation, which the copyright laws explicitly preclude from protection. They also mentioned that there's really no sweat of the brow protection in copyright. It may have taken you a lot of work, but it's only the creative elements that otherwise pass this merger doctrine and command structure restrictions that could be protected. So in the district court, we've got some comments here from people that were involved. The jury foreman was interviewed by a journalist, and his characterization was that the jury felt that Oracle's intellectual property would have been against the public interest, which is sort of interesting because it wasn't a question so much of the specifics of what was copied, but just that it seemed wrong to give Oracle protection over the sorts of things they were seeking. But on the other side, there was also a feeling that Google had sort of done something wrong here. The parties certainly trumping their own positions, trumpeting them as loudly as possible. On Google's side, they want to say that there's a line of cases that say anything that deals with interfaces and interoperability in software is something that deals just with abstract ideas, things that are not copyrightable. Oracle, on the other hand, wants to get right down in the weeds and look at specific things that were copied, and they've really emphasized how they did win on a little bit of copying. So the parties have appealed. Oracle is making some interesting arguments here in the sense that they're really pointing out how software is treated very differently from other types of work under copyright law. And to them, this isn't fair. Copyright law doesn't provide as robust a coverage for functional utilitarian works as it does for things like works of literature. So they try to draw some analogies to other types of cases outside the realm of software to kind of highlight how there's different treatment. I've got a few examples here on the screen, cases that they've cited. I won't go into them at all in detail, but some of the things that are, that they're arguing about are the ways that other types of works that still have a functional aspect have been granted copyright protection. One is a case from another circuit that dealt with taxonomies for dental procedures. You may have encountered these. Lots of different medical procedures will have manuals that are put out by various organizations detailing how to code and diagnose certain conditions and have that in sort of a common format that is sort of an industry standard. Those things have been found to be copyrightable. But here, Oracle has a complex taxonomy, if you will, for how you organize different elements of software packages. But they emerge with no copyright protection. So to them, that's a bit of an unfair result, that copyright is accorded a lesser status than these other types of works. Another analogy would be perhaps you're familiar with library classification systems like Dewey Decimals, which is a copyrighted system for organizing books in a library. And it's very similar in terms of what Oracle is trying to argue here. I guess one way to think about it is if you are familiar with a particular book and you know that it's available on a university campus library. You know that it's in the engineering library on the second floor, third row in, second shelf, fourth from the end. You know that book is saved there. Without thinking, you can go find that book because you know where it's stored. In this Oracle case, what Google was doing was utilizing that familiarity that programmers had with the Java language and the Java platform and leveraging that as they wrote their own Android operating system. So rather than have computer programmers learn a new system with a new set of names, a new classification system where they'd have to look up all these common functions each time they wanted to use them, they used the same organization as in Oracle's Java platform. And you can see Oracle sees that as a different outcome than what would be happening outside the realm of software. Now for Google, at least on appeal, well, they mostly won at the district court level. So they are, of course, arguing that the district judge was brilliant, came to the right conclusion, and probably of all the cases they're arguing about here in precedent, this Lotus versus Borland case is the closest. That dealt with spreadsheet software, some of the early programs, Lotus 123 and Borland's Quattro. Lotus 123 was the market leader. When Quattro was released, it included what they called a Lotus emulator. This allowed a user to run the Quattro program, but have all the menus arranged in exactly the same way that they appeared in the Lotus program. The court there, First Circuit Court of Appeals, said not copyrightable. The menu system is not copyrightable because it dealt with interoperability. That decision was widely viewed as being sort of consumer friendly, not allowing protection on something that had become sort of an industry standard and that consumers relied upon to make use of the program. Interestingly, that went up to the Supreme Court, but with Justice Stevens not participating, there was an equally divided decision. So for a lot of people, that line of cases is settled. Despite the fact that the Supreme Court didn't issue a definitive opinion, nonetheless, courts have tended to follow this. But it remains controversial, and this is what, in essence, Oracle is challenging. They think it should come out the other way. So there's lots of amicus briefs here. This is a widely watched case. Of the amicus briefs, if you're interested in looking at them, Ralph Oman, the former Register of Copyrights, had an interesting set of comments. But there's lots of different opinions here on both sides of the issue. So this is going to be a case to watch for a lot of reasons. I suspect that because the case has gone to the Federal Circuit, but they're applying Ninth Circuit law, the chance of the Federal Circuit really upsetting case law in the Ninth Circuit on this is probably pretty slim. But we're dealing with parties here who very well may try to slug it out all the way to the Supreme Court. So until we get to that point, this may still be an open question. And certainly there's a lot of different sort of policy arguments on either side of this debate. Probably an analogy you might draw here is that in late 2012, the Copyright Office reversed its position on unlocking cell phones. So they said that now unlocking a cell phone to allow it to be used on different phone carrier networks it would constitute copyright infringement. And although the issues aren't completely parallel, you can see there that there's this tension. In different settings, interoperability is not so much a concern, but here interoperability is precluding any protection for Oracle. And oftentimes the argument is, well, this is really a functional aspect. You should protect it with patents. But if you look closely at this case, it would be very difficult for Oracle to get meaningful patent protection on what's at issue here. If you recall, Alan Koink this morning mentioned a case with SAP where something was ruled a non-patentable subject matter. That's the sort of challenge that a company like Oracle faces. Patent protection would be difficult. Copyright protection, as you can see here, not always available. And things like trade secrets are really of no avail when you're talking about a system that kind of needs to be open and people need to have access to be able to make use of it. So it's an interesting case. I think it's one that should be watched, and probably in the short run, I wouldn't make any rash decisions just based on the district court case, but this has the potential to really change the face of copyright law when it comes to software. So thank you very much.